Good day everyone. I am Christine Rata Baybayanon, the group leader of this group, and my members are Lester Abadier, Percival Alipid Jr., Riza Antoniega. We are the group 1 and we are here to tackle about the chapter 2, which is the essential requisites of a contract. From Article 1318 to Article 1329.
Article 1318. There is no contract unless the following requisites concur. 1. Consent of the contracting parties. 2. Object certain which is subject matter of the contract. 3. Cause of the obligation which is established. Classification of elements of a contract. They are: first, essential elements of whose without which no contract can validly exist regardless of the intentions of the parties. They are also known as requisites of a contract. They may be subdivided into A. Common or those present in all contracts, namely consent, object, and cause. And B. Special or those not common to all contracts, or those which must be present only in or peculiar into certain specific contracts. Natural elements are those that are presumed to exist in certain contracts, unless contrary is expressly stipulated by the parties, like warrant against eviction or warranty against hidden defects in sales. 3. Accidental elements of the particular stipulations, clauses, terms, or conditions established by the parties in their contracts, like conditions, period, interest, penalty, and etc. And therefore, they exist only when they are expressly provided by the parties. Article 1319. Consent is manifested by the meeting of the offer and the acceptance upon the thing and the cause which are to constitute the contract. Offer must be certain and the acceptance absolute. A qualified acceptance constitutes a counteroffer. Acceptance made by letter or telegram does not bind the offeror except from the time it came to his knowledge. The contract, in such case, is presumed to have been entered into the place where the offer was made. It is the conformity or concurrence of wills, offer and acceptance. And with respect to contracts, it is the agreement of the will of one contracting party with that of another or others upon the object and terms of the contract. It is the meeting of minds or mutual assent between the parties on the subject of matter and the cause which are to constitute the contract. Even if neither has been delivered, mutual assent or agreement takes place when there is an offer and acceptance to offer. Requisites of consent. There must be 2 or more parties. Number 2, the parties must be capable or capacitated. 3, there must be no reiteration of consent. 4, there must be no conflict between what was expressly declared and what was really intended. 5. Intent must be declared properly. Offer is a proposal made by one party, offeror, to another, offeree, indicating a willingness to enter into a contract. It is more than an expression of desire or hope. It is really a promise to act or to refrain from acting on condition that the terms thereof are accepted by the person to whom it is made. Offer must be certain and seriously intended. Offer must be certain or definite so that the liability or the rights of the parties may be exactly fixed, because it is necessary that the acceptance be identical with the offer to create a contract without any further act on the part of the offeror. Examples: will you buy this watch for 5,000 pesos? This is an example of an offer. Example number 2, I am willing to consider the sale of my land to you for 150,000 pesos. The offer here is uncertain. Its acceptance will not create a contract. And example number 3, I am willing to buy your car. There is no offer because it is incomplete. No price is given. Number 4, I am willing to sell my car for 250,000 cash or for 6 monthly installments for 42,000 pesos. The offer here is certain. Here, the determination of the manner of payment is left to the offeree. An offer made in jest or in anger, or while emotionally upset, or in other ways indicating that the same was not seriously intended is not a valid offer. But lack of serious intent to enter into a contract where such a condition was not apparent to the offeree who honestly believed that the offer was seriously intended does not invalidate the offer. Acceptance is the manifestation of the offeree for his assent to all the terms of the offer. Without acceptance, there can be no meeting of minds between the two parties. Acceptance of offer must be clear and absolute. Basically, a contract consists of an offer and an acceptance of that offer. The acceptance of an offer must not only be clear, it must be absolute, unconditional, or unqualified. That is, it must be identical all respects with that of the offer so as to produce consent or meeting of minds. If acceptance is qualified, as when it is subject to a condition, it is mere constitutes a counteroffer which, in law, is considered a rejection of the original offer and an attempt by the parties to enter into a contract on a different basis. Article 1320. An acceptance may be expressed or implied. Form of acceptance of offer. An express acceptance in the form of a promise to pay a certain amount or to do something, may be oral or written. An implied acceptance is one that is inferred from act of conduct. As an example, X promises to pay Y 1,000 for repairing his refrigerator and making it run again. Here, only X, offeror, has promised to do something. By doing the request act, Y accepts the offer. If Y accepts the offer by promising to do the requested act, a bilateral contract result. There are promises on both sides. It has been held that where a person accepts the service of another, whether solicited or not, he has the obligation to pay the reasonable value of the service thus rendered upon the implied contract of lease of service, unless it is shown that the service was rendered graciously or without any expectation that he would pay for the same.
Hi, I'm Percival Alipit and I will discuss 3 articles talking about offer. According to Article 1321, the person making the offer may fix the time, place, and manner of acceptance, all of which must be complied with. Again, the person making the offer may fix the time, place, and manner of acceptance, all of which must be complied with. In this article, the party who will accept the offer made by the other party must comply with the requirement given, so that in the special cases of offer, it must have a consent to have a perfect contract, or else, if not completed, there will be no contract. Like for example, Mr. Bean offers Teddy an customized car after his graduation at the college. If he will accept it, he must finish his study so he can get the car. Since the Article 1321 states the maker can set his offer, it is clear that in the example that the contract will be completed if complied to. Next, in the Article 1322, an offer made through an agent is accepted from the time acceptance is communicated to him. Again, an offer made through an agent is accepted from the time acceptance is communicated to him. In this article, it tells us about the extension of authority by using an agent of the party to communicate to the other party so they can have a continuous transaction to the party who will accept an offer so that the consent given to the agent will make a contract. For example, ABC Insurance Company sent an agent to Santan family to discuss the offer from the company, and the agent will then send a report if there is unconsent given by the Santan family. In this article, since there is an acceptance agreed through an agent, the contract is valid as from the Article 1322 supports the use of agents. In Article 1323, an offer becomes ineffective upon the death, civil interdiction, insanity, or insolvency of either party before acceptance is conveyed. Again, an offer becomes ineffective upon the death, civil interdiction, insanity, insolvency, or either of the party before acceptance is conveyed. Through this article, an offer is extinguished in the time the other party, or either of them, had died, civil interdiction, insanity, insolvency, because, in that case, party cannot have any consent from it, and also acceptance of an offer that gives the contract completed. Like for example, Mr. Mike is given an 1-week period to accept the offer made by the insurance company that will give him enough compensation he wanted in the future. But days before the period, Mr. Mike passed away by the accident happened near the road last stormy night. So, because of that, a party cannot make a contract because, as per Article 1323, states the reason. So that's all the special cases from an offer that covers 3 articles. I hope you can apply this in making an offer to other person or parties.
1324. When the offer has allowed the offeree a certain period to accept, the offer may be withdrawn at any time before acceptance by communicating such withdrawal except when the option is founded upon a consideration as something paid or promises. When the offer gives to the offeree a certain period within which to accept the offer, the general rules is that the offer may withdraw as a matter of the rights, and any time before acceptance. The exception is when the option is founded upon a consideration as something pay or promise. So, example po is X offers to construct the house of Y for a very reasonable price of 1,000,000 given the latter 10 days within which to make up to his mind.
Article 1325.
Useless is appears, otherwise business advertisement of things for sale are not definite offers, but mere invitation to make an offer. So, yung ano po is business advertisement of things for sale are not definite offers. Acceptance
of which will perfect construct but are merely invitation to the reader to make an offer. So, yung example po nito is yung for sale 200 square meter lot at Greenlands Village, Quezon City for 1,900,000. Tel number is 844-1284. This is not a definite of
Article 1326.
advertisement for bidders are simply invitation to make proposal, and the advertiser is not bound to accept the highest or lowest bidder unless the contrary appears. So yung in a advertisement for bidders, the advertiser is not only the one making the offer. In reality, the bidders is the one making the offers, which the advertiser is the free to accept or reject. Acceptance by the advertiser of a giving bid is necessary for a contract to exist between the advertiser and the bidders regarding of the terms and conditions.
Chapter 2, Essential Requisites of a Contract. Article 1327, the following cannot give consent to a contract. Number 1, unemancipated minors. Number 2, insane or demented persons and deaf mutes who do not know how to write. This Article 1327 tackles about the capacity of a person before entering into a contract and to give consent to the agreement. Unemancipated minors are one of the followings that cannot give consent because they are not in the legal age, which is the 18 years old and above, and they are subjected by parental guidance. Insane or demented persons cannot give consent to a contract because of their illness, and with their case, they are detached from reality and they don't know what they are doing, so that they are not capable to give consent unless they are acted during lucid interval. Deaf mutes who do not know how to write because they are not capable to understand things about the agreement unless this deaf mute person know how to read and write and capable to understand different things and can enter to a contract. For example, Katie is a minor and she is a student of Mater Equiche. They have educational outbound at Shercon Resort, Lipa, Batangas. She wants to join and she asks for a letter of approval or letter of consent from her teacher for her parents to allow her to join with this program. But on that day of submission of letter, Katie forgot to inform and sign her by parents the letter. Kung hindi niya pipirmahan ito, hindi siya makaka-attend. So, she decided to sign it. And after that, yung teacher niya napansin na iba yung pirma sa magulang niya. So, the consent or the contract are not valid and voidable. Thank you. Article 1328, contracts entered into during a lucid interval is valid. Contracts agreed to a state of drunkenness or during hypnotic spell are voidable. What is lucid interval? A brief period during which an insane person regains sanity sufficient to have the legal capacity to a contract and act on his or her own behalf. Lucid interval is a temporary period of sanity, where the person is in the state of drunkenness, where the contracts agreed upon these states are avoidable because they are in the situation of drunkenness that temporarily results in a complete loss of memories or understanding, that equivalent to a temporary insanity, and also during hypnotic spell or gayuma, induced by drugs or by deliberate hypnotism. And therefore, one party is incapable of giving knowledgeable consent, and contracts agreed in all these states are valid and voidable and can be annulled by a proper action in court. And for example, Kelly claimed that he was drunk when he was made to sign the deed of sale of his motorcycle. However, the drunkenness person will state to be a ground of voidability. He must prove that it was such as to interfere with the normal functioning of his rational faculties. Article 1329, the incapacity declared in Article 1327, subject to the modifications determined by law, and is understood to be without prejudice of special disqualifications established in the laws. This article is directly concerned to the incapacitated person, such as unemancipated minors, insane or demented persons, and deaf mutes who do not know how to write, that is subjected to the modifications determined by law. There are instances that these persons are incapacitated and they can still give valid consent and enter into a contract. For example, there is a contract involves the sale and delivery of necessaries such as food to minor. Then this minor needs to pay because it is considered as valid. Contracts involve insurances like life and health insurance and etc. Then the contract will valid as well. And the contract will also be considered as valid if entered into their guardians or legal parents. And also the contract will be valid as well if the minor lied regarding with their age and he told that his age is 18 above and the other party is agreed and that he said that he is in legal age, then it is resulted as a valid contract. And also the other special disqualifications may be provided by law are under the rules of the court. The following are considered incompetence and may be placed under guardianship, such as persons suffering accessory penalty of civil interdictions, hospitalized lepers, prodigals, deaf and dumb who are unable to read and write, those who are of unsound mind even though they have lucid intervals, and those persons by reason of age, disease, weak mind, and other similar causes that cannot take care of themselves, and it is easy to anybody to take disadvantage to them. Thank you.